Hello friends. Today we are going to discuss about an important topic, the psychiatrist and the consumer court. In simple word, what are the implications of Consumer Protection Act of 2019? I'll be discussing with the recent case and how does it will apply to psychiatrist. I'm Dr. Suresh Badadmat, professor of psychiatry, working at National Institute of Mental Health and Neurosciences, Bangalore. As I mentioned earlier, I'll be discussing about an important case law and what are the legal implications from Consumer Protection Act 2019 and what should the psychiatrist or the psychiatrist across the country should do. This is an important case, that is Subhash Chandra Sarkar versus Dr. DJ Shea 2022. This is a decision taken by West Bengal Consumer Forum and I'll be discussing about this case. In this case, I have made certain changes so that the identity of the patient and also certain doctors' name is not brought into forefront. That is, professional confidentiality has been tried to maintain by changing certain information in the case law without losing the essence of the case. Mr. S, a 27-year-old mechanical engineer working in central government in 2005, had a first episode of depression. The first episode of depression occurred in 2008. He approached a Dr. KM in a metropolitan city and he was given treatment. In 2000 July, he was treated and by January 2009, he returned back to work. Unfortunately, within 6 months, he had a relapse of the illness. But as per the family members, he was on medication. Since he had a relapse, the family members went to another senior psychiatrist, Dr. JN. Dr. JN accepted the case, started treating him. Within few months, the patient improved and he went back to duty. And even during resuming to duty, a certificate was given that he was declared to fit to work. But again in July 2010, within few months, he had a relapse of symptoms. Recognizing the seriousness of his illness, patient's father again brought him back to Dr. JN. Dr. JN prescribed some medication and advised to take medicine on outpatient basis. But patient's father said they are finding it very difficult to manage him at home. He was expressing suicidal ideas. He had tried to commit suicide. Hence, the patient father requested for admission. This is the life history of the patient. You can see the life chart. The first episode occurred in July 2008. And within 3 to 6 months, he improved, went back to work. Within 6 months, he had a second relapse, June 2009. Again, the medication was given. He went back to work. Unfortunately, again, in July 2010, he had a relapse and he was brought back for admission. That is the present episode. So, here, the Dr. JN felt that since their father said he is unable to manage him, he advised him to admit in a local nursing home, which was managed by Dr. DS. Dr. DS was an MBBS doctor, that is, RMO of that hospital, running the nursing home. He was in charge of that nursing home. Dr. JN psychiatrist used to visit as a visiting consultant into this hospital. The hospital was completely under the control of Dr. DS. And when the patient was admitted, the Dr. JN gave his personal mobile number and also his wife's number to the patient's family member if they required to contact. And finally, the patient was admitted in the nursing home of Dr. DS. The family members clearly told Dr. DS the patient is suicidal. He has suicidal ideas. He may attempt suicide anytime. Hence, the Dr. DS gave a information, and an attender was also hired. The attender was hired 170 rupees per day to look after the patient. And this was in 2005. Patient's father visited the patient after a few days. He found that the patient was improved, talking nicely. But the doctor said he will be discharged in a few days after complete improvement. Tragically, on 12th of August, Mr. S. death by suicide occurred. He hanged himself with a rope in the toilet of the hospital. The hospital came to know in the morning at 6 a.m. The hospital gave a police complaint. The body was sent to postmortem. Father was informed. Father tried to contact the psychiatrist, but his phone number was switched off. By the time the father came, the hospital waived off all the hospital bills since there was a tragic event, and the cremation was done after the postmortem. The father wanted to know, how did he commit suicide? In spite of admission, in spite of hiring a attendant, how did he commit? His father came to know that his son used a rope which was used to restrain another patient in the ward. Unfortunately, after restraining the patient, that means his another patient in the ward, that rope was left behind. That means that rope was available to the patient, that to Mr. S. And without anybody's knowledge, he took this rope, went into the toilet, and hanged himself. Father requested for the medical records, but the doctor did not respond. And after repeated request, the doctor gave in writing telling that the medical records are with the police. Of course, whenever the death occurs inside the hospital, a police complaint is given. It is the duty of the police to take the dead body, to submit for postmortem, send the medical reports or medical records for opinion whether there is a criminal negligence or not. This is as per Jacob Matthew versus State of Punjab 2004 case, as per the Supreme Court order. Father came to know through the postmortem the patient had died in the night, and they came to know only in the morning. In spite of being an attender, how can he get the rope and how can he die? Hence, he gave a police complaint. A complaint was also lodged in the State Medical Council, and finally in the Consumer Court asking for 92 lakh rupees as a compensation in 2005. This is the facts of the case. Unfortunately, when the case was going on, Dr. DS, that is the RMO of the hospital, dies. He expired in 2015. Invariably, only the Dr. JN, psychiatrist, was fighting the case. But as per the Consumer Protection Act, if one of the respondent dies, he has left behind property, then his children and his spouse will become the respondents. Similarly here, the children and the wife was made the respondent of the case. And finally, in 2022, approximately 17 years after the case, the State Consumer Court gave its verdict, upholding that there was a medical negligence and awarded 50 lakh rupees compensation to be paid by Dr. JN and the children of Dr. DS. This is the case. Now let's look into the case as an analysis. This is my personal critical opinion. Here, the negligence was declared based upon two important facts. Although the attender was available and it was hired by the family member, how did the patient get the rope? Why the rope was left behind when they knew the patient was suicidal? That is one. The second important point the State Consumer Council has brought is the specialist mobile phone was switched off. Patient father tried to reach him many times. It was not available. And they tried the doctor's wife's number also. Through that, they were able to reach him. Unfortunately, Dr. DS died in 2015 and none of his family member contested. Although the spouse and his children were named in the case as per the consumer court. And unfortunately, there was a tussle between the hospital Dr. DS and Dr. JN, telling who is responsible for the death of the case. Invariably, specialist said, I am a visiting specialist, I am a psychiatrist, I will give my opinion and go. It is the hospital which needs to look after the case and provide standard of care. And there was no suicidal protocol to prevent suicide was followed in this case. And further, absence of proper documentation, absence of indemnity insurance with the doctors. Invariably, the children may not fight or they may not know about the case at all. Although the case was made free of cost, I believe the case was not argued properly. And they had not put forward the international literature clearly saying that in 10% of the cases, in severe mental disorders, either it can be schizophrenia, bipolar, or severe depression, 10% of the patients do commit suicide. That is, death by suicide is common. This fact was not put forward before the state consumer court. This may be one of the drawback of this case. And not arguing the case is another important point. What are the implications of this case? Now, Consumer Protection Act of 2019 is implemented. What are the implications? The psychiatrists need to understand. Now, majority of the cases will be in the District Consumer Forum or District Consumer Commission. Why? Now, the Consumer Protection Act of 2019 clearly says that the bill paid by the patient towards the doctor, that is the consent rate, the bill, if it crosses 50 lakhs, then it will go to the State Consumer Forum. If the bill is less than 50 lakhs, it will be in the District Consumer Forum. Invariably, across the India, majority of the bill do not cross 50 lakhs. That means 99% of the cases will be instituted in the District Consumer Forum. That means you need to fight locally or in the district court. But if it crosses 50 lakhs and within 22 crore, then it is the State Consumer Commission. If it is more than 2 crore, then the National Commission. Unfortunately, there is another catch here. Territorial jurisdiction. What does it mean? If the patient wants to complain in his hometown, imagine, I'm a doctor at Bangalore. If I treat a patient from Rajasthan and he wants to give a complaint in Rajasthan in his district place, the patient has all the right and he can give complaint in his district place in Rajasthan. Now I need to fight the case going to that district and in the District Consumer Council. So not only it is the amount which decides which type of court, either it is a district, state, or national, the patient has the right to decide where he wants to give the complaint. So now, keeping all this information, adding one more important, if you lose the case in District Consumer Forum or in the District Consumer Commission, if you want to appeal to the State Council or Commission, you need to pay the 50% of the fine which was imposed by the District Commission. Imagine if they say you have to pay 50 lakh rupees to the patient. If you want to appeal, you have to pay upfront 25 lakh rupees, my dear friends. Hence, you need to have indemnity insurance. Without that, you may not be able to get the money or deposit 50% for the appeal, my dear friends. Hence, I request all the doctors, psychiatrists to have an indemnity insurance, not just because you're going to lose the case. If you want to appeal to the State Consumer Forum or National Consumer Forum, you have to provide or give 50% of the fine. This can be done only easily if the indemnity insurance is there. And invariably, you need to fight the case wherever the patient is there. And majority of the case will be in the district forum. Till date, I have not heard any of the psychiatry patients' bill has not crossed 50 lakhs. Invariably, it will be in the thousands or in lakhs, not 50 lakhs, my dear friends. Hence, knowing the case thoroughly, and if you are visiting a doctor or a psychiatrist to any nursing home, be careful, know the nursing home's capability, whether they have adequate resources, whether that hospital has taken permission under the Mental Health Care Act of 2017, Clinical Establishment Act. If anything goes wrong, you as a psychiatrist also will be pulled into the case. Knowing all these implications, my dear psychiatrist, please do practice reasonably and responsibly. Thank you very much for giving your valuable time. Stay safe and practice ethically.